Hello everyone, my name is Melissa Salm, and along with Team 3, we will be discussing disparate impact and the journey from Griggs to Ritchie. I will be introducing my team members and what they will be discussing, and I will also be going over the introduction of the case. Asia will cover Part 1, Griggs versus Duke's Power Company. Olga will cover Part 2, From Ward's Cove to the Civil Rights Act of 1991. Coleman will discuss Part 3, Ritchie versus DiStefano. And Jennifer will conclude and tie the case into our book. Before getting started, I would like to go over some important key terms so the article and cases can be more easily understood. Title VII is a federal law that prohibits employers from discrimination against employees on the basis of sex, race, national origin, and religion. It is important to also understand the difference between disparate treatment and disparate impact. Disparate treatment is a way of proving intentional employment discrimination, while disparate impact is a practice that is neutral or non-discriminatory in its intention but ends up affecting individuals having disability or belonging to a group based on age, ethnicity, race, or sex. Prima facie means something is accepted correct until it is proven wrong. A lot of the cases in the article are court judge-made law. There is a lot of debate between who should create the law, legislators or judges. Some believe the federal judiciary is only responsible for interpreting and applying the law, and under the separation of powers, legislators should make law. Others believe that it is inevitable that judges make law and also necessary because legislators cannot anticipate the issues and questions that arise in court. Essentially, courts fill in the gaps that statutes have, thus making law. The article focuses on judicial lawmaking in regards to anti-discrimination law Title VII of the Civil Rights Act of 1964. When enacted in 1964, Title VII only prohibited intentional employment discrimination on the basis of race, color, religion, sex, or national origin, and requires a finding that the employer have intentionally engaged in or is intentionally engaging in an unlawful employment practice charged in the complaint, which is disparate treatment. Proof of discriminatory motive is critical with disparate treatment. The article introduces a plethora of cases in which the court fills in the gap in regards to disparate impact. The court went through a long journey repeatedly creating judicial law, which will be discussed in the next slide. In Griggs versus Duke Power Company, it is an example of judge-made law in which the United States Supreme Court held that Title VII prescribes not only overt discrimination, but also practices that are fair in form, but discriminatory in operation. Disparate impact, which involves employment practices that are facially neutral in their treatment of different groups, but that in fact fall more harshly on one group than another and cannot be justified by business necessity. The court held proof of discriminatory motive is not required under disparate impact. Griggs was not the last stop in the journey through the Title VII disparate impact. Ward's Cove Packing versus Antonio, court made law when it made changes in the burdens borne by plaintiffs and employers in disparate impact. The Civil Rights Act of 1991 was Congress's response, essentially codifying disparate impact and setting out elements to the plaintiff's claim and employer's defense. Last, in Ritchie versus DiStefano, court made law again, creating a new rule governing an employer's decision to discard what the court believed to be disparate impact causing employment examination. All of these cases will be discussed in further detail in the next slides.
Good evening, everybody. My name is Asia Richards, and I will be discussing the Griggs versus Duke Power Company case. This case was broken up into two sections. First, we will be discussing the case and the court's decisions, then different case rulings after the Griggs court decision. The case questions whether an employer is prohibited by the Civil Rights Act of 1964, Title VII, from requiring a high school education or passing of a standardized general intelligence test as a condition of employment in or transfer to new jobs. The Civil Rights Act of 1964 prohibits employers from discriminating against employees on the basis of sex, race, color, national origin, and religion. At Dan River Steam Station, a power generating facility, Duke Power discriminated on the basis of race in hiring and assigning employees. The facility was divided into 5 different departments: labor, coal handling, operations, maintenance, and laboratory and test. Until 1966, no African American was employed in another department than the labor department. Labor department employees were paid a maximum of $1.57, while in other departments, the minimum wage was $1.71. The maximum wages ranged from $3.18 to $3.65 per hour. In 1955, the company adopted a policy requiring a high school education for initial assignment to any operating department other than labor. The requirement was subsequently extended to those seeking transfers from the labor department to another department. On July 2, 1965, an additional requirement was added for new workers seeking transfer, and this was the same date Title VII took effect. The 2 new requirements was 2 types of aptitude tests: the Wunderlich Personnel Test and the Bennett Mechanical Comprehension Test. African American employees filed a class action lawsuit against the company, alleging that the at-issue employment practices violated Title VII. The district courts ruled in favor of the defendant due to the plaintiff providing no evidence for their claim. When taken to the United States Courts of Appeal for the Fourth Circuit's ruling, they ruled in favor of the defendant, stating that the company's educational and testing requirements did have a general business purpose and that the company initiated with no intention to discriminate. By a vote of 8-0, the court reversed the Fourth Circuit ruling and held that challenged employment practices were prohibited by Title VII. The court ruled that both aptitude tests showed no demonstrable relationship to successful performance of the job for which it was used. The court also found that employees who had not performed satisfactorily on the aptitude test or completed a high school education actually did progress in their departments. The Griggs court case created a cause of action. They bridged a gap between the egalitarian ideals and everyday realities of the job market. The court did not question whether the company intentionally discriminated against African American employees. They asked whether the company's practice constituted artificial, arbitrary, and unnecessary barriers to employment, resulting in a disparate impact not justified by business necessity. The Griggs court went where the 1964 Congress did not go. The court made law. Court decision issued in years following Griggs gave further shape and content to the disparate impact law and doctrine. The disparate impact is a way to prove employment discrimination based on the effect of the employment policy or practice rather than the intent behind it. It constitutes the adverse effect of practice that is neutral and non-discriminatory in its intention, but nonetheless disproportionately affect the individual having a disability or belonging to a specific group based on their age, ethnicity, race, or sex. Last, we'll be discussing 2 court cases that were affected by the Griggs court ruling and the disparate impact law. The first case is the Albemarle Paper Company versus Moody. In this case, Albemarle claimed that their 2 general ability tests were needed in hiring decisions for promotion and were sufficiently job-related under Title VII. The district court actually ended up siding with Albemarle. When taken to the Court of Appeal, the court held that the employer's validation study assessing the job relatedness of the employment test was materially defective. They also noted that once a plaintiff or class makes out a prima facie, which is based on the first impression and accepted as correct until proven otherwise, of discrimination, the employer must prove that its tests are job related. The Court of Appeals found several flaws in the employer's test and remanded the case back to district court for further ruling. The next case is Dothard versus Rawlingson. Diane Rawlingson was actually applying for a police officer position in a correctional facility in Alabama. The case addresses a plaintiff's disparate impact action challenging the minimum weight and height requirement for all law enforcement officers established by an Alabama statute. The plaintiff established a prima facie case as evidenced by the percentage of women excluded from work opportunities due to the weight and height requirement. As the plaintiff and defendant went back and forth trying to provide their case, The court ruled that if strength was a job-related quality, the employer should have adopted a validated test directly measuring strength of the applicants. Thank you for listening.
Hello everyone, my name is Olga and I will be continuing the presentation. The Greek disparate impact theory remains controversial. Under this theory, an employee can violate Title VII even in the absence of evidence that the employee intentionally discriminated on the basis of race, color, religion, sex, or national origin. Resistance to Greeks became official government policy with the election of Ronald Reagan to the presidency in 1981. Worscove Packing Company versus Antonio was an opportunity to oppose to Greeks' disparate impact theory. In Worscove, the court considered a disparate impact action brought by a class of non-white salmon cannery workers against employer operating salmon canneries in Alaska. Unskilled cannery jobs on the cannery line were filled mostly by Filipinos and Alaska natives, and skilled non-cannery jobs were filled with mostly white employees hired from Washington and Oregon. District Court rejected the plaintiffs' claims, and they appealed. The United States Court of Appeals for the Ninth Circuit reversed that decision, saying that the plaintiffs had made out a prima facie case of disparate impact in hiring, and then the employees bore the burden of proving that any disparate impact caused by their hiring practices was justified by business necessity. Supreme Court reversed that decision of Ninth Circuit by narrow majority 5-4, ruling in favor of the employer and placing the burden of proving disparate impact on the plaintiffs. Majority opinion stated that cannery workforce composition differed significantly from that of qualified job applicants, and the Ninth Circuit's ruling was consistent with neither precedents set by the courts nor with Title VII. The majority reviewed the Ninth Circuit's holding that the plaintiff's prima facie case was established by comparison of the percentage of non-white cannery workers and the percentage of non-white non-cannery workers. Additionally, the cannery workforce didn't have enough qualified employees who could be considered for non-cannery jobs. Therefore, comparing the number of non-whites occupying non-cannery jobs to the number of non-whites filling cannery work positions is not correct. However, minority opinion stated that Greeks made clear that in disparate impact cases, the touchstone is a business necessity, and also that Greeks correctly reflected the intent of Congress that enacted Title VII. Also, minority mentioned that Congress can revisit the statutory scheme and can correct the court's mistakes if the court misread Congress's meaning. So, as we can see, Worscove is an example of judicial lawmaking. Congress responded to Worscove in the Civil Rights Act of 1991. One of the stated purposes of the Act was to codify the concepts of business necessity and job-related enunciated by the Supreme Court in Greeks and in other Supreme Court decisions prior to Worscove. The Act amended Title VII, Section 703 by adding subsection K. The amendment provides the framework for establishing the occurrence of an unlawful employment practice. It states that the plaintiffs have to demonstrate that each particular challenged employment practice causes a disparate impact. This is not required when the plaintiff can show that elements of the defendant's decision-making process cannot be considered individually. So, therefore, the burden of proof is on the defendant to show that any disparate impact is caused by business necessity. Thank you, and now Coleman will continue the presentation.
Firefighters in New Haven, Connecticut that are looking to promote to lieutenant or captain must take a city-administered exam. However, once the results were counted, white candidates were noticed to have scored significantly higher than minority candidates on the exam. In the captain's exam, the passing rate for whites was 64%, while the passing rate for blacks and Hispanics were both 37.5%. For the lieutenant exam, the passing rate for whites was 58.1%, while the passing rate for blacks and Hispanics were 31.6% and 20% respectively. Out of fear of facing a possible lawsuit, the city discarded the test results and no promotions were made. This caused outrage from the potential passers of the exam. It's quite ironic that the city's actions were, in fact, to avoid a lawsuit because that's exactly what they got. The white firefighters and one Latino firefighter who predicted that they would be promoted due to their test results sued the city and claimed that they had been subjected to intentional disparate treatment discrimination on the basis of race in violation of Title VII. The city argued that discarding the test results was necessary to avoid exposure to liability in any disparate impact suits brought on by the minority firefighters. Justice Kennedy was the deciding vote in a 5-4 ruling in favor of the plaintiffs. The court stated that unless the employer can demonstrate a strong basis in evidence that they would have been liable under the disparate impact statute, Title VII rights will be considered violated, and that they were. The problem the city faced was that their only reason for not certifying the exam results was because of the statistical disparity based on race. And because the city's actions were considered race-based by the court, it was decided that Title VII rights were violated, whether intentional or not. Justice Kennedy began a search for a standard that would give effect to Title VII's prohibition of both intentional and unintentional discrimination. The standard which he added was the strong basis in evidence. He took this from a clause in the Equal Protection Clause in the affirmative action cases. These cases held that certain race-conscious government actions remedying past racial discriminations are constitutional only when there is a strong basis in evidence that the remedial actions were necessary. Justice Kennedy's decision was met by dissent from multiple justices, led by Justice Ruth Ginsburg, because it did not include important parts of the story. One part that Ginsburg wanted to focus on was that firefighting has a legacy of racial discrimination that reached very far deep into history. In the 1970s, African Americans and Latinos made up 30% of New Haven's population, but only 3.6% of the city's 502 firefighters. After a lawsuit that was said to bring on positive change, by 2003, 30% of the city's firefighters were African American and 16% were Latino. The fire department's senior officer ranks were 9% African American and 9% Latina, and one of the department's 21 captains was African American. Ginsburg mentioned that it is against this backdrop of entrenched inequality that the promotion process at issue in this litigation should be assessed. Justice Ginsburg ultimately determined the opposite of Kennedy's ruling and that he was wrong. She stated that the employer must have good cause to believe the device would not withstand examination for business necessity. She also believed that New Haven had ample cause to believe its selection process was flawed and not justified by business necessity. She questioned the form of promotion evaluation and why it was so heavy reliance on a written test when many other cities have indicated that alternative methods were more reliable and less discriminatory. The court ultimately decided against Justice Ginsburg's ruling and in favor of Justice Kennedy's ruling, stating that there was no evidence that the tests were flawed because that they were not related to the job or because other equally valid and less discriminatory tests were available to the city. In a post-Rickey lawsuit, an African-American firefighter sued New Haven, alleging that the city's promotion examination violated Title VII's disparate impact provision. The court spoke in conflict of its ruling on the Rickey case, and unfortunately, New Haven had to suffer the whipsaw effect of defending in a disparate impact suit the very same test which the city had certified by the order of the court.
Hello everyone, my name is Jennifer Monroe and I will be concluding Team 3's presentation. As a review, Equal Employment Opportunity, EEO, is employment that is not affected by illegal discrimination. EEO laws are enforced by the Equal Employment Opportunity Commission, EEOC. Employers are required to make status-blind employment decisions without regard to an individual's personal characteristics such as age, sex, race, etc. As we've learned, basing employment decisions on factors other than worker qualifications is illegal. When violations occur, litigation costs and penalties can be substantial. Disparate impact has been a part of the Title VII doctrine since Griggs v. Dukes Power Co. affirmed the existence of a disparate impact cause of action in 1971. Griggs v. Dukes Power introduced us to a landmark case on disparate impact. The Supreme Court ruled that lack of intent is not sufficient for an employer to prove the practice is lawful. Additionally, the employer must demonstrate that there is no reasonable, non-discriminatory method available to use. Under the federal government's Uniform Guidelines on Employee Selection Procedures, disparate impact is determined with the 4/5 rule. If the selection rate for the protected group is less than 80% of the selection rate for the majority group, or less than 80% of the majority group's representation in the relevant labor market, discrimination exists. In the example on the slide, disparate impact exists because the female selection rate is less than 4/5 of the male selection rate. This example of internal disparate impact is taken from our textbook, Human Resources Management, 15th edition, located in Appendix D. Connecticut versus Teal was consistent in their focus on protecting individuals. In 1982, the Supreme Court additionally fortified the disparate impact theory in Connecticut versus Teal by rejecting an employer's bottom line defense. In its defense, the employer contended that although the test at issue caused a disparate impact upon minorities, the result of the entire hiring process rendered no disparate impact because minorities were proportionately hired and promoted. The court emphasized that it was unquestionably clear that the obligation imposed by Title VII is to provide an equal opportunity for each applicant regardless of race, without regard to whether members of the applicant's race are already proportionately represented in the workforce. Now, let's fast forward to 2009 with Ricci versus Di Stefano. The city was faced with a prima facie case of disparate impact liability because the pass rates for the Hispanic and African American test takers fell below the 80% rule. Again, this slide demonstrates the disparate impact example. Consequently, the city refused to certify the tests and thereby voided the results. The city found itself stuck between Title VII disparate impact and disparate treatment provisions. Although it avoided discrimination lawsuits from African American firefighters, the city was ultimately sued by 17 Caucasian firefighters and 1 Hispanic firefighter who passed the test and believed they would have been promoted. The plaintiffs' firefighters argued that the city violated the Equal Protection Clause of the 14th Amendment in the disparate treatment provision of Title VII of the Civil Rights Act of 1964. Conversely, 18 years after Griggs, the Supreme Court revisited the question and reached an opposite conclusion. In Ward's Cove Packing Co. versus Antonio, the court held that the goal of Title VII is to remedy only intentional discrimination. The significance of Ward's Cove decision is that Title VII was amended. In the Civil Rights Act of 1991, Congress redefined the disparate impact cause of action in a manner that reversed Ward's Cove significantly by codifying the disparate impact cause of action. The Civil Rights Act of 1991 requires that employers show that an employment practice is job-related for the position and consistent with business necessity. Additionally, the Act clarifies that plaintiffs bringing discrimination charges must identify the particular employer practice being challenged and must show only that protected status played some role in their treatment. For employers, this means that an individual's race, color, religion, sex, or national origin must play no role in employment decisions. The Act allows people who have been discriminated against to receive compensatory and punitive damages. The inconsistent choices made by the Supreme Court do not reflect Title VII's text. Should there be a call for a third Reconstruction to achieve the workplace equality that Congress has now made clear is Title VII's goal? Robert Belton, a professor of law at Vanderbilt Law School, states that it seems clear that the disparate treatment theory, standing alone, will not remedy the continuing effects of past societal discrimination against racial minorities and women. It appears that, at least for the foreseeable future, legislative resurrection of the Griggs disparate impact theory is the most promising first step in ushering in the third Reconstruction. Regardless of age, gender, creed, race, color, origin, disability, etc., individuals should be hired and promoted on the basis of their qualifications or job performance. As the workforce continues to become more and more diverse, organizations should create policies to educate employees on misbehavior. HR personnel should understand EEO laws and use diversity training within organizations that allow employees to capitalize on their diverse characteristics. We hope you have enjoyed our presentation. The subsequent slide will provide our references. Do you have any questions? Thank you for your time.